what it's really like living in Maine.
About 47% of able-bodied people in the state of Maine don't work.
The reason 47% of able-bodied people don't work is not because the people are lazy. It's because the Maine government has totally ruined all industry by over-regulation and over-taxation. Because of this government misconduct, Maine has no more jobs except in government. There are no more mills or manufacturing of any products anymore in Maine. Every large corporation that was in the state realized that it is cheaper to go anywhere else and do business than in Maine. Smart people know doing business in Maine is simply not worth it. Maine does have one area of manufacturing it excels in, the manufacturing of lawbreakers. It's sad, but in this world there are wolves and sheep. Guess which one you are? The wolves are government and the sheep the rest of us. Since there are no jobs in Maine, and government employees outnumber manufacturing jobs, the legal system has been designed to extract as much money possible from you by use of prosecutorial malfeasance or prosecutorial bias and misconduct. If you have money, this is no problem. If you are poor, disabled, or considered weak, you're an easy mark to pay large fines and sit in their jail so they can collect federal funds and forcibly sell you everything you need while in their custody. The reality is, jails are now a booming for-profit business in Maine and throughout most of the United States. And as we all know, for-profit businesses need customers, just like you, a willing participant or not.
Like an insane asylum.
Thoughts of suicide come a lot.
Unless you're in the club. If you don't know, there's a special, exclusive, unofficial club in Maine. The people in this unofficial club call it the Good Old Boys Club. And in this Good Old Boys Club are police, judges, attorneys, politicians, probation officers, and other state employees, as well as their families. The people not in this very exclusive club are the other people, or general public. In order for people in the Good Old Boys Club to live lavish lifestyles, they must extract wealth from the other people. But if there are no jobs, and the other people have no wealth, how do the people in the club take something the other people don't even have? The answer? Use every dirty trick in the book. Maine depends on a continuous stream of lawbreakers, so the manufacturing of lawbreakers is now top priority. Laws in Maine are not made for any sort of public safety anymore. Laws in Maine are made for maximum revenue generation only. Maine is so dependent on lawbreakers, it's using the citizens' own cars against them. Police are riding around running license plates of cars parked in people's driveways. If the person has a warrant or bail conditions, they get raided. That's if they think they can take money or property. Maine now uses outright entrapment by suspending a citizen's driver's license before going to court for an offense, and not telling them about it. Then they tell the local police in their area to keep an eye out for them. Unaware of any license suspension, the citizen gets robbed by use of outright entrapment, guilty, before even going to court. This is totally illegal, but Maine does it all the time. There are several professional police agencies in Maine, but in some towns, especially towns that surround major destination cities, they have an entirely different type of police. In these towns, the local police job is not to protect and serve. Their job is to extract as much wealth as possible from as many people not in the club. These towns are at war with vehicles, the passengers, and the contents it may contain. They are thugs whose job it is to take the wealth from the public with traffic violations. And nowadays, simple traffic violations turns people into felons. And being a felon makes you a continuous customer for the state. Each of these towns has a very strict quota that must be reached each month by each officer. Therefore, most of these towns tend to hire officers that have been kicked out of other departments. Since ethical behavior is not a concern whatsoever and only making money is, they are welcomed into these towns with open arms. Maine also redesigned the license plates so low IQ police can run them much easier. Using the new design, the members of the Good Old Boys Club also get their own special version of the license plate. This version allows police to quickly identify members of the club and concentrate on people not in the club. As we all know, the job of the district attorney is to prove that a crime that violated state laws happened and recommend a punishment to protect the public. They are not supposed to be biased or discriminate against that person based on the sex of that person. In Maine, any of that just don't exist. All Maine courts outright discriminate based on the sex of a person.
The prosecutor's office is doing terrible things and committing terrible crimes.
The district attorney's office does not get cases from the public. We get them only from law enforcement. You can't call and say, here's a report, I want somebody prosecuted. We would refer you to law enforcement in whatever jurisdiction.
There's an employee at the DA's office in Hancock County, a county employee, who has a dispute with a relative. And that employee manages to convince the district attorney's office to file charges against that employee's cousin's husband for operating after suspension. Now, that complaint is based completely on that employee's statement that that person saw the cousin's husband driving. The DA's office files the complaint and brings charges. The normal sentence for something like that, or the normal plea offer, would be for a fine. But in this particular case, they ask for a jail sentence. The cousin's husband decides that he wants to have a trial. I'm appointed to represent this gentleman. And he asks for a trial, and we file a request for discovery. The DA's office completely ignores that request for discovery. 2 months go by. I file a request for sanctions. The court sanctions the DA's office and fines them $300 for not providing discovery to this defendant. What should make you angry, what makes me angry, is that the DA's office allowed an employee to use that office for personal vendetta against a relative. And what should make me even madder is that tax money that was to be spent to protect you as a community was turned over to the state as a penalty for them not doing the job. And that's why I believe I'm the best candidate for this position, because I won't let that happen. And I will make sure that your tax money is used appropriately and that nobody uses that office for any type of personal gain.
Mr. Foster,
Excuse me, you're out of order.
See him in jail.
Excuse me, I'm sorry, you're out of order.
Well, I'm responding to exactly what he said. Judge Mallory said, I'll see him in jail. He still has no license.
Personal situations here.
It's not personal. I'm required to have a license. His client should be also.
The district attorney's office does not get cases from the public. We get them only from law enforcement. Only from law enforcement. Only from law enforcement. Only from law enforcement. Does not get cases from the public. Only from law enforcement. Only from law enforcement. Yes, sir.
If you are elected, how do you plan to break the cycle of misconduct in the office?
I don't think there's a cycle of misconduct in the office.
You don't believe it exists?
A cycle of it? No, sir. No. Only from law enforcement. Thank you.
You walk through that door, that courtroom door, you have no rights. They want to get you, they want to prosecute you, they will find a way.
The reality of the Maine court system is, if you are charged with any crime in the state of Maine, you are automatically guilty of that crime. There is no innocent until proven guilty. There is no guilty until proven innocent. You are automatically guilty, and that's it. Unless you have large sums of money or you are a woman, you are guilty.
You are convicted before you even walk through that door. There are so many victims, people getting violated, families being destroyed, going on welfare, losing their businesses.
I was wrongly accused and falsely prosecuted. There was no circumstantial evidence. There was so many questions. There were so many professionals that discredited findings, and I was prosecuted anyway. In my opinion, it turned into be a witch hunt, and I was guilty automatically. And it destroyed a big portion of my life. And it's not fair.
Assistant District Attorney by the name of Mary Kellet. She was the first prosecutor to be disciplined by the Maine Supreme Court for misconduct. 7 counts of misconduct, including destroying evidence, telling police officers to destroy evidence that can prove the innocence of an individual. She has said there are many different cases. She even told police officers to disregard court orders.
A state ethics board has issued a report on a prosecutor in Hancock County saying she engaged in conduct unworthy of an attorney. The Maine Supreme Court will have the final say on whether Assistant District Attorney Mary Kellet should face any punishment. The report comes out of a recommendation the Maine Board of Overseers of the Bar made last year that said Kellet should be suspended for violating 7 rules of the bar during a sexual assault case she prosecuted in 2009. Kellet has until mid-May to respond to that report. Then one member of the Maine Supreme Court will hold a hearing on Kellet's conduct and decide if she should be suspended.
I wish the district attorney's office would have that moment of, we need new perspective.
Most of the people that this DA's office targets are people who they feel are weak, who are not willing to stand up for themselves. This is something that's been going on here for close to 30 years. I personally investigated about 100 different cases where they either destroyed evidence, purposely lied in court, had no evidence, or in some cases didn't even charge the individual because they were friends with the district attorney's office.
A local woman who was the district attorney's friend won't be prosecuted for her role in an accident that killed a pedestrian in Trenton last year. Gilio, 31, initially faced charges after the April accident that resulted in the death of Arthur Smith Jr., 29, of Steuben. She was behind the wheel of a 2001 Dodge Caravan when she struck Smith just before 1 a.m. as he was walking in the middle of the southbound lane of Route 3 at the time of the accident. Police initially suggested rain and fog likely were to blame for the nighttime collision, but said later that tests indicated Ihol had alcohol in her bloodstream when a vehicle struck Smith. Earlier this year, Ihol made a first appearance in Hancock County Superior Court on prospective charges of aggravated operating a motor vehicle under the influence of intoxicants, driving to endanger and reckless conduct. Hancock County Deputy District Attorney Carletta Bisano said Tuesday, however, that Ihol is not being prosecuted. The status of this case at this point is that it is closed, Bisano said. The prosecutor said the Hancock County Sheriff's Department and the District Attorney's Office thoroughly reviewed and investigated the case and tried to pursue felony charges against Ihol. We did what we could do with that case, Bisano said. That case went through that process and it simply did not survive. We did not draw up charges in this case. But if it was a man, we would have prosecuted him for murder. A review of published Hancock County grand jury indictments since the accident indicates that Jill Ihol never was indicted in connection with the fatal collision. Unless the defendant agrees to waive indictment, felony charges cannot formally be filed in Superior Court without a grand jury indictment. When asked about the lack of a grand jury indictment, Bisano declined to comment. She said grand jury proceedings are confidential and are not considered public. The reality is, the grand jury is made up of her friends. Smith's father said that Ihol was not given a blood alcohol test right away when police arrived at the accident, and that some have suggested his son was partially to blame because he also had been drinking and was walking in the road. Hancock County Sheriff William Clark said Tuesday that, as far as the investigation goes, his department did everything appropriately. We did what we needed to do, Clark said. Understandably, Mr. Smith is upset. I stand behind the investigation we did. Bisano said she understands the frustration of Smith's family. I feel terribly for them, she said. Ihol was represented by Ellsworth attorney Daniel Pileggi before the case was closed without formal charges being filed against his client. A woman who answered the phone Tuesday at Pileggi's office said he is on vacation this week and cannot be reached for comment. Arthur Smith SR said he still thinks Ihol should be charged, even if it will never bring his son back. There were things done that weren't done right, the father said. I just don't understand it. I guess I never will. The truth is Chilao worked for Jeff Tupiker, who worked for Carla Ibisano, the district attorney. This is just one example of the corruption in Hancock County, Maine.
There is a distinction in the law between simple mistakes for which officers like that are immune and purposeful conduct that violates constitutional rights for which they're not immune.
Not just happening here. This is happening all over the country. And unless you actually can file a bar complaint, nothing's going to be done.
How difficult is it to win a disciplinary action against an attorney or a prosecutor? Well, the answer is very difficult because most people don't know how to do it. First of all, look up on the internet the rules and regulations for the attorneys that are in your state or in the state that may have violated their code of ethics. If it's about funding or financing or what they did, or if they have a conflict of interest or any violation, it'll be spelled out in the rules and regulations as what they can do and what they shouldn't do. Using that, then file the complaint that you have with the regulatory board and submit it very specifically and put in the evidence that you have. Add it. Say that the attorney said this and did this and you have a transcript that something else happened. No, then you write that, you submit that transcript. The attorney then receives a copy of the complaint and then must answer it within a certain period of time. And in most states, I think all of them, you are allowed to have the answer that the attorney files with the regulatory board. Then you must take a look at that and see where he falsified or did not properly answer the questions, and then go after him again. You must be relentless and don't give up. The attorney's going to continue to lie and falsify stuff to try to get himself out of it, and you must be telling the truth, you must be ethical, you must be honest, and you must prove everything you say, and then the attorney will be disciplined.
Basically, the legal system being allowed to control the public. As soon as you walk through that door, that courtroom door, you have no rights. They want to get you, they want to prosecute you, they will find a way.
As the number of false convictions and exonerations keep piling up, but is anyone ever held accountable? A new piece by Radley Balco in the Huffington Post today takes a look at prosecutorial misconduct in the United States and how a system of self-regulation and professional sanctions just isn't enough.
Prosecutors have what's called absolute immunity from civil liability in these cases. So you cannot sue a prosecutor virtually under any circumstance.
Diplomatic immunity.
There are a few very limited windows you can get through, but for the most part, as long as they're acting in their role as a prosecutor, even if they manufacture evidence that results in your conviction and you're innocent, egregious negligence. On the criminal side, it's rare, vanishingly rare for a prosecutor to face any sort of criminal sanctions in these sorts of cases.
People who aren't accountable to anybody probably are going to make some mistakes.
During the 1980s, there was a major shift in the Congress and in state legislatures about how long sentences should be. The public was alarmed by increasing rates of crime from the 1970s and early 80s, and they wanted longer sentences. They wanted cracking down. And that's what happened across the board for all kinds of crimes, not only the mandatory minimum drug sentences.
The effect of all those sentencing laws was not just to increase the sentences that people were exposed to, so that people were serving longer time in prison than they did before. It was also to take the discretion away from the sentencing discretion, away from judges and juries, and shift it over to prosecutors. It didn't eliminate discretion, it just gave prosecutors the power to determine what your sentence was going to be by making charging decisions, and even by bargaining over what the facts of your case were. So it didn't mean that discretion was eliminated from the system, it just put the prosecutors in charge.
Prosecutors can negotiate with you behind closed doors. It's not open to the public. It's not reviewable. There's no appeal available in the way that you're negotiated with. And they can basically say to you, if you plead guilty or if you cooperate and you give us other names, we'll cut you a deal and we'll only charge you with one of these charges instead of these three. And you'll get 5 years instead of 15. So all of that goes on behind closed doors. And they say to you, if you don't cooperate with us, if you don't agree, we're going to file a motion because you have a prior from 10 years back. We're going to file a motion called an 851. And if you go to trial and lose, your 5-year sentence is going to be doubled to 10, or your 10-year sentence is going to be doubled to 20. Or we can even, if you've got 2 priors, it'll put you in prison for life. But all the decision about how they charge these, what charges they bring, knowing what the sentences will be, that's all done behind closed doors. It's absolutely not open to the public. It's not open to review by a court even. And so the power of the prosecutor is huge in determining sentences today. And I don't think prosecutors are per se bad people, but I think power is seductive, and they have a lot of power, and they like it, and they get to not just rack up a victory, a win, but they can also say, and he's going to prison for 25 years.
There are a number of ways for a prosecutor to commit misconduct. Prosecutor malfeasance can take many forms, including abusive investigative practices, threats, and other coercive tactics, lying to eyewitnesses, forensic fraud, and framing the innocent. The most common forms of prosecutional error that are relevant to domestic violence and sexual assault cases are charging without probable cause, engaging in selective prosecution, concealing evidence, failing to enforce perjury statutes. If you're in Maine, be prepared for the district attorney and your court-appointed attorney to do any of the following. Engage in conduct unworthy of an attorney. Engage in conduct prejudicial to the administration of justice. They may fail to employ any reasonable skill or care whatsoever. They may fail to make disclosure of the existence of evidence that tends to negate the guilt of the accused, mitigate the degree of the offense, or reduce the punishment. They may suppress evidence they had a legal obligation to produce. They may employ means that are inconsistent with truth and seek to mislead juries and judges. Prosecutors may refuse to communicate with defendants. They may false claim they can only communicate with other attorneys. Prosecutors may tamper with evidence. Prosecutors may falsely claim you had bail or other violations in the past during a trial or hearing, when in fact you did not.
It is said around the country, tens of thousands of individuals, mostly men, are wrongfully prosecuted every year. A lot of this is due to prosecutorial misconduct. Mary Kellet, her discipline by the Maine Supreme Court, for the 7 counts of misconduct, all she received was a 30-day suspended sentence, as long as she did 6 hours of continuing education classes.
The Board of Overseers of the Maine Bar says for the first time ever is recommending a prosecutor's license to practice law be suspended. The panel found Hancock County Assistant District Attorney Mary Kellet in violation of ethical standards. Among the violations, engaging in conduct unworthy of an attorney. News Center Samantha Edwards joins us now with details. Samantha?
Thanks, Chris. This review stems from a 2009 case where Kellet prosecuted a man on charges of rape against his wife. The man was acquitted and filed a complaint that Kellet did violate bar rules during her prosecution. Now, the man argues Kellet did not have probable cause or enough evidence in her case against him. A 3-person panel spent 2 days reviewing the evidence of the case against the Hancock County ADA. Prior to the hearing, Kellet held a clean record and cooperated with the board throughout its investigation. But one group, Stop Abusive and Violent Environments, spent the last year highlighting Kellet's actions and pushing for the state to take action.
This was a pattern of misconduct that occurred over a period of months and even years that involved Mary Kellet and other people in that same office of prosecutors in District 7 of the state. So this was not just a one-time incident or because prosecutors were overworked. This is really a problem of a pattern of a systemic prosecutorial misconduct that was documented not just in this one case.
The board did find 2 points of concern through its investigation. First, Kellet's rebuttal during the trial highlighted the absence of evidence and caused prejudice toward the defendant. This was evidence that she had argued to keep out of the trial. An expert on the panel described this move as stubborn and that she appeared to be bucking the court during her rebuttal. The second point found Kellet withheld 2 key pieces of evidence from the defense. The evidence was the 911 recording from the night of the alleged rape and some witness statements. Members of the panel say the seriousness of this issue cannot be overstated. and that it was Kellet's ethical obligation to produce the evidence. Kellet argues she and her colleagues did not find the evidence important to the defense's case. These findings are what led to the panel's decision to recommend suspension. It's a decision Penobscot County District Attorney Chris Almy is concerned by.
It's a difficult situation, but and for not just Mary Kellet, but for all prosecutors, because this decision that they make reflects on how we're supposed to do our job, and I'm not sure that they've got it right.
Chris Almy says the suspension of Kellet would add strain to an already short staff and heavy workload. But her suspension is by no means a certainty. Kellet will appear before a justice of the Supreme Judicial Court. That justice will then make that decision. We did try to speak with the Hancock DA's office and Kellet herself, but neither were available for a comment. Chris, back to you.
Okay, thanks very much for that report, Samantha.
They left her in power. She is still there prosecuting people. I also have evidence that they're continuing to do the same exact things. They did not learn their lesson, and that is a big problem here for this community. Under the Constitution, we all have a right to a fair trial, but you're not getting it. You're not getting that fair trial. You are convicted before you even walk through that door.
There is a policy of no-drop prosecution that's pursued here in the Ellsworth area and other parts of the state. If you go to the website of the district attorney, it says, quote, "As district attorney, I will vigorously prosecute all cases." That statement is unethical on its face because prosecutors are required to respect the principle of probable cause. So this no-drop prosecution policy is unethical and it's bad because it hurts victims who have to wait in line for their case to be eventually be heard. But there's another side to this, and it involves a prosecutor who we believe is out of control. A prosecutor pursues cases even though they lack probable cause.
All Maine counties practice this level of corruption and prejudice. The entire system is corrupt. After being arrested, your first court appearance or arraignment is nothing more than a fishing expedition. I watched as my so-called lawyer of the day walked over to the district attorney's table in the courtroom, picked up the file they had on me and several other people, and walked over to me, opened it up, and started asking questions, like what do you have for bail and the value of property, stuff like that. This lawyer wrote down the answers in the file, then placed it right back on the district attorney's desk. A few minutes later, when standing in front of the judge, the DA opened the file and see what the lawyer of the day wrote down in there, and then told the judge they wanted bail well above what you just told that lawyer of the day. This proved to me that the court-appointed lawyers in Hancock County court system work hand in hand with the district attorney's office to convict you. Upon investigation, it was clear that nearly all court-appointed lawyers are nothing more than an extension of the district attorney's office. If you have no money, you will be forced to sign papers requesting a court-appointed attorney. Once signed, you are now considered ripe for the picking by the district attorney's office. The reality is, your court-appointed attorney's job is to help the district attorney convict you, using you to wipe their feet on as they climb the ladder of corruption and a better-paying job. Your court-appointed attorney will be working hand in hand with the district attorney to use you as a stepping stone and nothing more. Their job is to convict. The real truth is of no concern to them. Your court-appointed attorney will outright ignore requests for filing motions that may help you. And if you file your own motions because they ignored you, they will get mad and dismiss themselves as your lawyer, causing you to have to get another lawyer. Your court-appointed attorney will ignore requests for viewing evidence against you. They will outright lie to you about anything. If you try to communicate directly with the district attorney may false claim they cannot talk to you. Your lawyer has to. District Attorney Carletta Pisano, during trial, told Judge Ann Murray how bad a person I was for leaving Hancock County. There's no law whatsoever on that, just couldn't leave the state at the time, but she sure made it sound like I violated some law. I feel the reason that pissed her off is you can't be victimized by Hancock County if you're not in it. She also explained to the judge how bad a person I was for living alone. She called me a recluse in a tone of voice like it's a disease or somehow illegal. Her corrupt court and biased court system is the reason I chose to live alone. I don't trust anyone, and it's not illegal to live alone. She told the judge that I violated not one, but 2 bail conditions that didn't even exist. She didn't say what they was for or how I violated them. She just said it right there in the court, made it up on the spot. My lawyer, Robert Van Horn, knew it was not true. When I whispered to him those bail conditions was a lie and to tell the judge that, he told me to shut up. District Attorney Kellet told police to lose 2 dash cam videos that would have proven that I didn't do what I was being charged with. She then coerced a police officer to outright lie in court. Upon reflection, it was apparent that this is just typical behavior for the District Attorney's Office, police, and Van Horn or any other court-appointed attorney to do this. Robert Van Horn knew those videos would have proven I was not guilty, so my own lawyer helped convict me. Van Horn also refused to talk to me a full week before the trial. Then he turned on me the second I was on trial.
Citizens have a right to face their accusers, a right to see the evidence presented before them. But prosecutors can withhold that evidence. The evidence that can prove your innocence, a lot of times, they make it disappear. And that's what's been happening here in this community. So basically what it's doing is they have their own agenda. They target individuals, they target the weak, they target the people who they won't stand up for themselves.
Nothing stopped Prosecutor Mary Kellet from forcing this case to go forward through abuse of her position of trust and power as a state prosecutor.
An angry victim of misconduct by a prosecutor makes his point before a Maine Supreme Court justice, and in return receives an apology from that justice.
And I do apologize on behalf of the state of Maine for your first trial.
Vladek Filler was convicted of gross sexual assault in that first trial, prosecuted by Assistant District Attorney Mary Kellet. Filler has consistently maintained that his wife fabricated the rape allegation in an attempt to gain custody of their 2 children as their marriage deteriorated.
This has destroyed my life, my reputation. It has ruined me and my entire family financially.
Filler was granted a retrial by the Maine Supreme Court. In that second trial, he was found guilty of the lesser charge of assault and acquitted of rape. During her prosecution of the first trial, the bar panel found that comments Kellet made during her closing argument were prejudicial against Filler, and that she failed to turn over at least 2 key pieces of evidence to the defense. She now admits those mistakes.
I want to acknowledge that I made errors in the prosecution of the Vladek Filler case. I accept full responsibility for my misconduct, and I regret the harm that my mistakes caused.
Filler pushed to have Kellet disbarred, but the judge accepted an agreement calling for a 30-day suspension. Kellet's attorney says it's the first mistake she's made in a career prosecuting more than 10,000 criminal cases.
During the 10-plus years that she's worked as a prosecutor, she's been a faithful and dedicated public servant.
While Mary Kellet does have the mark of being suspended against her, she will not actually have to serve that suspension. That's because the judge suspended it. That means she will be able to continue her work as a prosecutor with the district attorney's office.
Who polices the prosecutors?
Sadly, no one really polices prosecutors. I mean, there are these disciplinary committees.
I've been on the Board of Overseers for 8 years. I've sat on those committees. I've done those decisions.
That oversee all kinds of attorneys, civil attorneys, corporate attorneys, copyright attorneys, entertainment attorneys, and also prosecutors themselves. And those committees do operate largely in secret. When someone makes an allegation that a prosecutor has withheld evidence or suborned perjury or committed any other number of things that violate bedrock prosecutorial principles, those complaints aren't public and the responses to those complaints aren't public. They only become public once the disciplinary committee decides to pursue pretty serious action. There's only been one prosecutor in about 10 years who's been subject to any form of investigation on the part of these disciplinary committees, even though we know that there are dozens of prosecutors who have committed serious misconduct, some of which leading to innocent people going to prison for crimes they didn't do. And those prosecutors have largely gotten away with this form of misconduct for many years.
You know, it's very interesting because I know here in California, and I could speak to that because I'm an attorney, and I've seen this, that you basically have to murder somebody to lose your bar license or even to be disciplined. It's very difficult to discipline an attorney. And I've wondered, I mean, when we talk about prosecutors, where do the majority of the complaints come from? If it, I would assume, comes from somebody who is a defendant in a case, they're already working at a disadvantage in terms of their credibility. But even when other lawyers blow the whistle, so to speak, on a prosecutor, perhaps a defense attorney, does that garner any more attention to a particular case or not? Does it seem to make any difference?
Civil attorneys tend to, complain about each other all the time. But with regard to criminal attorneys, it doesn't happen as much. And part of the reason why is because defense attorneys are intimidated. They're scared to report on prosecutors. They've got to work with those prosecutors for years in the future. And it's important for them to maintain those relationships in order to properly and most effectively represent their clients. If they have a bad relationship with the district attorney's office, it can make things like plea bargains really difficult. That's what their clients depend on them to do.
If you are elected, how do you plan to break the cycle of misconduct in the office?
I don't think there's a cycle of misconduct in the office.
You don't believe it exists?
A cycle of it? No, sir. No.
Prosecutors routinely withhold evidence that could be helpful to the defense, and rarely is anything done about it.
I'm a former United States attorney. I locked up a lot of people. I believe in the department. I believe in its mission, but the department is in real trouble. This is serious business. These career prosecutors believe that nobody can touch them. Nobody. That's a very dangerous thing in a free society.
When prosecutors get into the heat of battle, something takes over. The competitive spirit, their reputational implications, and they want to win at all costs. They then begin to think, if I lose this case, it will be very bad for me professionally, because I'll be known as the lawyer, the prosecutor, who lost a case that may be very visible.
And if the prosecutor gets it wrong, who's to know?
Right now, the standard is a prosecutor says to himself, well, this information I have, is it really material to the defense? Can you imagine such a standard? Here's your adversary deciding whether it's material to your defense. They don't think defensively. They don't know what your defense is, and yet they've got to make that decision.
Prosecutors, whether at the Justice Department or down at the county courthouse, are the most powerful actors in the criminal justice system. They decide who gets charged and what they are charged with. Life and death decisions in some cases. And when they themselves violate the law, when they withhold evidence or even fabricate a case, they cannot be sued. They have absolute immunity for their official acts.
They can intentionally engage in wrongdoing, obtain a conviction, put a person in jail for decades, and when caught, there's no lawsuit that can be brought by that individual person who's just lost a decade or two of their lives.
It will also require accountability, meaningful sanctions for those prosecutors who themselves fail to follow the law.
It all started shortly after Michael Povich got elected as district attorney. Povich quickly got the reputation of total bias and corruption around the town of Ellsworth. He, as district attorney, was now the king of the town, taking payoffs for reduced or non-existent sentences for anyone he knew. This was the new normal in Ellsworth, and still is to this day. That nearly changed in the early 1980s when a barmaid took a snapshot of Povich and fellow corrupt attorneys, Peter Roy and Jeff Toothaker, doing cocaine and splitting up money at a local club. This photograph came to haunt Michael Povich, until he handed the reins over to Carletta Bassano. whosoever possessed the photograph could not get into any legal trouble. This was proven time and time again to the locals. You always knew who had the photos by reading the local, corrupted newspaper, the Ellsworth American. So how can a newspaper be corrupt? The Ellsworth American newspaper minimizes local corruption coverage, while exaggerating the poor people's crimes. This newspaper is also famous for taking payoffs for keeping your name out of the paper altogether. You have to pay them off by press time, or they will put your name in the weekly edition. Before Michael Povich can retire and hand the throne over to the ultimate manhunter, Carletta Bisano, he has to get the photo back after all those years of being blackmailed with it. If he don't get the photo back before retiring, the photo will be of no use to the blackmailer. So the blackmailer will make it public. Povich could not allow that. The solution: wait until old Jimmy is out for the evening. Hire a burglar to break into Jim's safe and steal the photo. The theft was a total success. No one was ever charged or even investigated for the burglary of Jim's safe. Shocking, isn't it? Now that the blackmail photo was taken care of, Povich can now hand the throne of the Hancock County District Attorney's Office to Carletta Bisano. Bisano's reign of terror against men will last a total of 4 years. She just hates men. She is overheard saying on multiple occasions, all men deserve to go to jail for something they have done. Once in office, Bisano immediately hired Mary Kellet as Assistant District Attorney together with the help of Bill Entwistle and Paul Cannanaugh. They will participate in a cycle of misconduct that will victimize hundreds of men over the next few years. The next order of business for Bisano and Kellet is to work with their close friends at Next Step. The Next Step is simply a coaching service working with the District Attorney's Office to quickly obtain a protection from contact order. Bisano and Kellet both know that as soon as the fight is over and the woman cools her temper, they're going to get back together. So the woman is immediately rushed over to Next Step for coaching. Since the woman coach at Next Step knows the protection from contact order and just what to say on it, she will ask questions like, "He must have pushed you or touched you." If that don't work, she will say, "He must have hurt your feelings in some way." The coach will twist that around and write down psychological torture on the protection from abuse request. This process is repeated until the coach is certain the request is granted. Once the protection from contact or abuse order is signed by the judge, Bisano and Kellet spring into action. They send the police to where they think they might get together. Once caught together, the man is automatically arrested and goes to jail. Even if the woman seeks out the man, it is a mutual get back together. The fight is over and they have all made up. The man goes to jail. The goal is, if Bisano and Kellet can get a violation of a protection order, the man will get automatic jail time, have to post bail, get large fines and probation for a year or 2 minimum. If the man cannot post bail, the man will have to see a judge within 72 hours. This first hearing is called a arraignment. When it's really an assessment. The goal is to figure out what you can post for bail, so the district attorney can ask for more than you can afford. At this arraignment, you are issued a lawyer of the day. Your lawyer of the day will pick up your file from the district attorney's desk, walk over to you and ask how much you can afford for bail. He will write down your response and set the file back on the district attorney's desk. Minutes later, you will be standing in front of the judge, and the district attorney will be asking for a lot more than what you told your supposed lawyer. Your lawyer of the day works for the district attorney, not for you. If you cannot afford a lawyer, a fake lawyer will be appointed to you at no charge. If the court considers you weak, disabled, or poor, you will be appointed a court-appointed, master manipulator lawyer like F. Tupiker, Robert Van Horn, Charles Helfrich, or William Blaisdell. These lawyers will work directly with the district attorney to keep you in jail. These lawyers will lie and manipulate you, like the professionals that they are. They will not file motions you request. They will not show you evidence against you. They may conspire with the district attorney to hide evidence that may help you. They may conspire with the district attorney to manufacture evidence against you. If you get one of these crooked lawyers, you definitely want to file a Maine bar complaint form against them. These criminals have gotten away with this cycle of misconduct for years. The only way to stop them is to file valid complaints against them.
So how would you feel to get a court-appointed lawyer, only to find out later on that they was working hand in hand with the district attorney's office to convict you? Learn how to file valid bar complaints at despicablemaine.org. Maine judges, prosecutors, and the court-appointed lawyer will get together before your trial and discuss what the outcome will be. A trial in Maine is really just a formality with the outcome decided well in advance. This is why Maine judges will always favor prosecutors and never the defendant under any circumstances, unless they're in the club. If you would like a jury trial in Maine and you are not in the club, be prepared to be directly threatened by the district attorney and your court-appointed attorney with 10 times more jail time, or they will imply that you will get the maximum amount of jail time allowed by law if you are convicted at a jury trial instead of taking their plea agreement. If they think they can get away with it, your court-appointed attorney may also false claim you cannot have a jury trial at all and must take the kangaroo plea agreement. Maine courts also interpret the U.S. Constitution however they wish for people not in the club. Judges in Maine will outright false claim you have no right to a court-appointed lawyer if you are not looking at jail time for an offense. This is a direct violation of the U.S. Constitution, yet they do it all the time. If a man cannot post bail for an offense, at trial the prosecutor will require you to go to trial in jail clothing and be led into the courtroom in handcuffs, shackles, and a belly chain, all for effect. This trick is used by Maine prosecutors all the time for men who they have weak evidence against for a crime and they decided they are going to shaft anyway. If you are a man in Maine and you're not in the club, a charge of operating after license suspension will get you more time than a charge of molesting a child. To maximize profit for the people in the Good Old Boys Club, once convicted for an offense, Maine courts always require their propaganda therapy and counseling for everything. Jurors that are not in the Good Old Boys Club will see little or no court-required counseling recommendations. In order to maximize revenue, jury rooms in Maine are purposely designed to be very small and super uncomfortable. They all have a large desk you can barely walk around and hardwood seats with no padding. The jury room will have windows that do not open and a radiator blasting away in the corner that cannot be turned down or turned off. Since the real truth of the matter is of no concern whatsoever to the court, they want the jurors to be as uncomfortable as possible so they reach a decision that has been decided by the court days earlier. The court knows that when people are in an unusually small, very hot, very uncomfortable room, they are going to do whatever it takes to get out of there as quickly as possible. The court knows that the most uncomfortable jurors will quickly favor the prosecution just to get out of that room. If you are a member of the Good Old Boys Club and charged with a crime, don't worry. There is another, much larger jury room, complete with carpeted floors, padded seats, air conditioning, and a microwave just for you. You will also get your own special juror as foreperson if needed. Upon investigation for this video, it was discovered that courts throughout Maine, especially Hancock County, have been using fake jurors for some time. When they want to win a case, members of the Good Old Boys Club just throw in a member as jury foreperson. Since different cases all contain different people, with the members of the Good Old Boys Club, or court staff and attorneys, the only thing that stays the same in each case, it is never noticed that the same special person is on the jury again. Keep in mind, as soon as you walk into that courtroom, the people on grand juries, district attorneys, judges, and court-appointed attorneys all have a financial interest in your conviction. A plea deal allows a former Lincoln County Sheriff's deputy to avoid retrial on 20 sexual assault charges in exchange for pleading guilty to a single misdemeanor count of providing a place for minors to consume alcohol. Deputy Kenneth Hatch III, Lincoln County, Maine Deputy of the Year in 2015, was charged with 22 counts of sexually abusing 3 girls when they were younger than 16, one when she was 6 years old. One victim described a number of occasions after she turned 14 when Hatch allegedly agreed to give her marijuana, at one point directly from a police evidence bag, or buy her liquor if she'd have sex with him. She said the two of them had sex about 10 times, and she estimated she went on 100 ride-alongs with him. The trial started with 2 girls testifying that Kenneth Deputy Hatch sexually abused them when they were 14 and 15 years old, often during ride-alongs. Both victims said he provided them with alcohol and marijuana from a police evidence room. The third witness, now 19 years old, said Hatch first abused her when she was only 6. Then when she was 14 and 15, she said Deputy Hatch gave her marijuana and liquor if she'd have sex with him, often in the back of his cruiser on Crocker Road near Hatch's home while on duty. They delivered their verdict less than 3 hours later. Maine Assistant Attorney General John Rissler said he is not sure why the jury found Hatch not guilty on those particular counts, which were among the 17 counts that involved one of the then 14-year-old victims. I'm disappointed we weren't able to secure a verdict. Just because it happened a long time ago doesn't mean it didn't happen. Those are the cases we want to take seriously. Rissler said following the sentencing that the likelihood of convincing another jury of guilt beyond a possible doubt was small. The option I had to protect the people of Maine was to remove his ability to serve in law enforcement, Rissler said. When he loses his certification from the Criminal Justice Academy, it's very unlikely he would ever be able to serve in law enforcement outside of Maine either. Richard Elliott, Kenneth Hatch's attorney, declined to comment following the verdict, but said Elliott Hatch is extremely relieved. He'd like to have seen all not guilty, but we live to fight another day. He said he's not sure why the jury found him not guilty on those particular counts. I'm extremely pleased with the jury we picked, Elliott said. Obviously, they considered it long and hard. I think any time there's a hung jury, it means they did. The custom-picked jury must have obviously considered everything long and hard. It took almost 3 hours to reach a verdict for a member of the club. Elliott said he was unsure of Hatch's status with the sheriff's office, but said that since Hatch was out on disability when he was charged, it would likely continue. He agreed to accept the misdemeanor for furnishing a place for minors to consume alcohol because he agreed to let kids drink on his property, and obviously he knew other kids were there. Elliott said Thursday he thought it would be safer to do it on his property than for them to be out driving around. Yet if you do it, they will throw your ass in jail so quick it ain't funny. Superior Court Justice William Stokes dismissed the 20 counts with prejudice, meaning Hatch cannot be tried on them again, and imposed the mandatory $1,000 fine. Assistant Attorney John Rissler, who prosecuted the original case against Hatch, asked for a 10-day suspended sentence, but Stokes said that was not an option. We do not sentence members of the Good Old Boys Club to jail, so Justice Stokes did not sentence Hatch to any jail time. Justice William Stokes declared a mistrial on the remaining charges, which included sexually abusing 3 teenagers when they were younger than 16 and one when she was 6, and providing marijuana to them. But Stokes said the original jury was an excellent pick and has been severely deadlocked, and that a new trial would have been very difficult. But Stokes said the original jury was an excellent pick, and it had been severely deadlocked. Maine State Attorney General Janet Mills issued a statement noting that prosecutors do believe the alleged victims. Mills said, "We support the victims, we believe them. Unfortunately, the jury the club picked did not find beyond a reasonable doubt that Mr. Hatch was guilty of these crimes. Fortunately, he will never work in law enforcement again." Deputy Kenneth Hatch was demoted in May 2013 from sergeant detective to patrol officer, according to an employment reassignment agreement. The document made reference to an investigation into a matter that the Maine Attorney General's office outright declined to prosecute. The single-page document does not specify what was investigated, but states, in the event of any future similar charge or incident, the department may use this matter in a future disciplinary proceeding, although this matter shall not be, by itself, the subject of discipline. Before the demotion, Deputy Kenneth Hatch also received 2 written reprimands, one in 2010 and another in 2012. Lincoln County Sheriff Todd Brackett reprimanded Deputy Kenneth Hatch in June 2012 for a serious breach of security and disregard of an official order, according to copies of the written reprimands. That action followed an investigation by Cumberland County Sheriff's Office on Brackett's behalf into the disappearance of an undisclosed amount of oxycodone pills that had been stored in the evidence room of the Lincoln County Sheriff's Department for 2 pending drug trafficking cases, according to the document. The investigation determined that the oxycodone stored in the evidence room had disappeared in late 2011, causing the 2 criminal cases to be dismissed. Conveniently, details about those 2 cases were not included in the documents that were released. Sheriff Brackett concluded in his reprimand of Deputy Kenneth Hatch that the then Sergeant Detective had disregarded a direct order given in the spring of 2011 to keep the evidence room key on his person. Instead, the sheriff said that Hatch had left the key in an unlocked drawer in his desk. The evidence shows that Deputy Kenneth Hatch failed to provide a secure environment for storage of evidence seized by our law enforcement agency, the reprimand stated. Deputy Kenneth Hatch also was given a written reprimand by Lieutenant Michael Murphy in February 2010 for conducting a criminal and motor vehicle violation background check through the state criminal computer system on his brother-in-law to provide him with a copy so that he could apply for a taxi license in Augusta. The then Detective Sergeant Kenneth Hatch had documented the search as being done as part of a criminal investigation. The lieutenant stated that Hatch's action in his initially denying that he was running the records request for his brother-in-law violated several policies, including adding false information in department records. Kenneth Hatch III was fired after a lengthy internal investigation. He had been on unpaid leave from the sheriff's office since he was charged in June 2016. This is a
Vladek Filler filed 2 motions with the court with Judge Robert Murray, the judge in this case. One of those motions was a stay of sentence, that is, requesting his sentence, his 21 days, be pushed forward. And the reason being, he was still receiving, and up until today was receiving, medical treatment for an automobile accident. He had some soft tissue injuries and spinal injuries as a result of a car accident. And he was receiving treatment, and he wanted to push his 21 days forward so that he could finish the medical treatment. He filed that motion 6 weeks ago. The second motion he filed was to have his new lawyer recognized by the court, which is necessary. Yesterday, the judge, Judge Robert Murray, told him that he had to get a sworn recusal from his previous lawyer and get another document signed, a whole bunch of holy fuck, what the hell. And Vladek Filler got all that done. And Judge Robert Murray denied his motions, denied the motion to stay, to push the serving of the sentence forward until he'd finished his medical treatment. So he's being denied medical treatment for an injury, and also declined to recognize his lawyer. So he's now in Mary Kellet's jail with no lawyer, which means that although Vladek Filler is the principal witness in Mary Kellet's disciplinary hearing, he will not be allowed out of his cell to come up and testify because he has no lawyer. This is a more blatant, a more flagrant and over-the-top example of absolute purposeful corruption of the court. You couldn't write it if you were writing a comic book. Judge Robert Murray and Mary Kellet have both got to go.
Public corruption. How to start cleaning up the swamp in your own backyard by holding public officials accountable. I had a judge that wouldn't let me speak in a motions hearing. Well, I filed a state case on him, and he's trying to get it moved over into federal court. But in his response, he called me a scofflaw. So in my response, I counterclaimed it. It says, defendant called plaintiff a scofflaw. I feel disparaged. He is going to hurt my feelings. At no time did I call him a petty, fogging shyster grubbing for filthy lucre. Neither did I assert that he cannot be the sharpest knife in the drawer as he is scrounging around in the municipalities rather than out there making the big bucks. With the court's indulgence, if counsel will just bend over, I'll gladly pull that wild hair out of his behind so we can go back to treating one another like mature and responsible adults. But then again, regardless of how many facts and law a pro se puts before the court, we never get no respect. Now, if you want to start cleaning up your own backyard and draining the swamp, because all these courts, so much of the money goes to the state, which so much goes to the federal government. So we can start choking them down and start making them where they're going to have to be held accountable for all this stuff. And this is what we do. And we're making some huge gains around here. So I just wanted to share that with everybody. I thought it was so funny. I just wished I was a fly on the wall to see what the judge's expression when he read that.
Well, and unfortunately, you may have crossed the line into a libel lawsuit by making that public. And again, you know, judges can be really mean about this stuff, especially when they're aware that they themselves are often committing judicial malpractice, but they don't want to be called on it by anybody. The mechanisms that we used to have to try and make sure that judges were being fair and honest and unbiased, those mechanisms have eroded over time, and we're seeing all kinds of judicial malfeasance all across the country. The system is hopelessly, irretrievably corrupt.
Well, you know, unfortunately, the way that they're going, we have to hold these people accountable. And if we don't start holding them accountable, it's just going to get even worse. And so that's the way we kind of feel about it around here. And we want these guys to follow the letter of the law. I mean, this guy wouldn't even, my whole suit was he wouldn't even let me speak in a motions hearing and told me to shut up, basically, which is illegal. And so once you call these guys out on it, they're going to have to start paying attention to all this stuff. So if he wanted to file any kind of suit against me, that means I get to ask for discovery, and that would not go very well for him because it's just going to prove my case even more.
Yeah, but your case is going to be tried. Your case is going to be tried in front of another judge who, in all probability, is golfing buddies with this first guy. Supposedly the judges are assigned to cases at random, so you can't go out and look for an honest, fair judge. You could be randomly assigned one who's even more corrupt than the judge you're trying to sue. And that's why a lot of these attempts to use the court system, to police the court system, come to no end. And now I'm not telling you to quit. I'm wishing you a lot of luck, but I'm saying be ready for a lot of opposition.
And that's the problem. Is there's two sets of standards in this country. There is this government class that likes to sit on top of us and be parasites and eat out our substance, and there's the rest of us. And we need to start standing up for our rights and stop letting the cops know who they really work for. They don't work for the Southern Poverty Law Center. They don't work for Barack Obama. They work for us. They work for you, and they work for me.
We have a government that is out of control, and not just for spending. I would agree with that statement as well. What do you plan to do about all of the violations that are going on in Health and Human Services, which are, I mean, just plain immeasurable?
I serve on the Health and Human Services Committee. There's a committee of jurisdiction. I am appalled at what has been happening, and we're trying to tackle this head on. It is not easy digging into the weeds and trying to see the source. There are significant concerns that stem back to the King administration. There was a company called Maximus. Maximus is still in existence today, although the state of Maine doesn't use them anymore. What their purpose was to maximize the federal match so that we could sort of creatively bill, and or it would be fraudulently bill, the federal government in order to draw down the federal match. As soon as Mary Mayhew became the commissioner, she discovered all kinds of interesting things that basically mean that the state of Maine owes basically hundreds of millions of dollars back to the federal government. We have a document in writing from August 16th of 2002 warning us about this in one area that we were fraudulently billing. And that document was put in a drawer and ignored.
From who?
From the King administration on through the Baldacci administration.
Right, but I mean...
So the Department of Health and Human Services ignored it.
But I mean, who sent it to them?
The federal government.
Yeah, okay, yeah.
That caught us. And then I don't know why, on the federal end, if someone says, hey, you're billing me fraudulently, you've got to stop, why they don't just stop the payments. I don't understand why the feds continue to give us the match. We continue to bill, and everyone just sort of looks the other way. It doesn't make sense to me. But that's the kind of thing we're dealing with, trying to figure out who, what, how, why, when. And that's just one small example. That was something called disproportionate share, which was billing for the prison population as Medicaid services, which they did not qualify for. And that we got caught in 2002. I don't even know when we began that billing process. So that, by caught, I mean we received in writing notification, but it wasn't until Mary Mayhew employee Jenny Boyden stumbled across it in this desk drawer that it even came to light, and that was this past year. So that's just one small example of the depth of the problem is enormous.
So they were billing the federal government for Medicaid services to inmates?
For the prison population, Dorothea Dix and at Riverview, but basically Dorothea Dix. So that population of people, we were receiving a federal match, billing the federal government for services that they did not qualify. We were never supposed to bill for those services. This is, but we've also done it with double billing. We have billed for children's services for both through the Department of Education and the Department of Health and Human Services. So we billed the federal government twice for the same procedure and received the federal match twice.
Oh.
Well, yeah. That was fresh out of the gate with Mary Mayhew. We had that. Then we also, I mean, it just goes on. We have had to apply and ask for forgiveness and said, basically, whoopsies, we're sorry, we double billed, we overbilled, we billed incorrectly, we weren't supposed to bill for this.
Why is Brenda Harvey in jail?
Good question. Should be right there with Paul Violet.
Yeah.
So
beyond.
I understand. I wish more people were paying attention and asking questions like you, because you try to get the message out, and it just seems to not be of great interest, I guess.
Well, do you know what the problem is? People have spent so many decades with the government having hearing problems, and nobody listening, that it has become, so commonplace that nobody even notices it.
I was only 7 years old.
Native American children taken from their homes by the state of Maine.
I have deep sorrows. Sometimes I break down.
We took their children, we took their future generations. No child should ever have to experience that.
A phone call to the state's Department of Human Services warned that an infant girl living in this building with her teenage mother might be unsafe. Caseworker Diane Sanborn's notes from that day.
Logan is a very beautiful child with brown curly hair and big brown eyes. Logan did not appear fearful of her mother, and in fact, because I was a stranger, was more attached to her.
What Christie had to work on was what DHS considered an unhealthy relationship with a boyfriend who had admitted using drugs. The department told Christie that she would have to follow a new set of rules. DHS service agreement.
Christie will not allow anyone to live, reside, or stay over until this person has been screened and approved by the Department of Human Services. Christie will submit names of people or person with whom she is or plans to be intimately involved, and shall not allow any contact between that person and Logan until assessed and approved by DHS.
One day, she left 2-year-old Logan with a babysitter at her mother's house. Mitch, who had previously moved out, showed up outside. He was spotted by a neighbor who called DHS. Citing Christie's failure to protect her daughter from the threat posed by others, the department immediately sought custody of Logan.
They went to court and they got an order saying that I was allowing my daughter around unsafe people. I'll take some of the blame. Sure, if I wasn't there, it wouldn't have happened. But at the same time, he wasn't supposed to be there.
Quick, this way, leave alone, come on. Come here.
DHS affidavit requesting Logan's removal.
Despite the department's involvement with Christie since June 1996, Christie continues to demonstrate recidivism under scrutiny, a clear sign that Christie is unable or unwilling to make the necessary changes to provide a home free from threat of sexual and emotional abuse. The department is asking for custody of Logan Marr to be granted to the state of Maine's Department of Human Services.
Hearing of the department's plan to take Logan, Christie took her daughter and fled, heading south towards Boston. But she realized her efforts to flee were futile and returned the same day. By the next morning, 2 caseworkers had come and taken 2.5-year-old Logan. She was now in the custody of the state of Maine. November 9th, 1998 service agreement.
Christie will sever all contact with her mother and demonstrate that she is able to maintain herself separately from her mother's negative influence. Christie will participate fully with the Department of Human Services, understanding this is the last attempt that the department is willing to make to reunify Logan with Christie, and that custody of her second child will also be in jeopardy.
To get Logan back, Christie, now a 21-year-old single mother of 2 young girls, would have to go it alone. After 7 months, satisfied that Christie had changed, the department returned Logan.
Where's your baby? I remember March 24th, she was home. She was back in my custody, and they closed the case in June.
Then she made 2 fateful decisions. She moved back in with her mother and attached herself to another boyfriend of questionable character, a convicted burglar named Paul. Before long, they were married. DHS reopened her case. They assigned it to an inexperienced child protective caseworker named Allison Peters. Peters received a tip, never confirmed, that Paul had hit Christie in front of Logan. She moved quickly, arriving unannounced at Christie's door with 2 police officers and a court order to remove her girls. The girls were driven to a foster home 2 hours away. It would be the last time that Logan would ever live with her mother. As Christie was struggling with the loss of her girls, DHS caseworker Sally Schofield had begun to think about adopting a little girl of her own. She had 2 boys, Derek, 14, from a previous marriage, and 1-year-old Shannon, but she had always longed for a girl.
I sort of felt like if I had 12 children, it'd probably all be boys. So I'd never get a girl. So we decided to pursue adoption.
DHS discourages its caseworkers from adopting children from within the system, but Sally was determined to be an exception. In her years at DHS, Sally had developed great confidence in her own ability to handle children. When a pre-adoption assessment made some critical comments, Sally complained so loudly that the authors removed the offending language. Sally Schofield's pre-adoption assessment.
When asked how she would deal with a child in a very challenging parenting situation, for example, a child who was out of control and not following the rules, Sally said she couldn't imagine a situation in which a child of theirs would be that far out of control.
In an effort to rescue kids from the limbo of foster care, the federal government had begun offering states like Maine financial incentives to place children in adoption. Also, biological parents were given less time to turn their lives around before losing their children permanently. By July 2000, her girls were still in foster care. Christy had only 8 months left to prove herself or face the likelihood of losing her daughters for good. Determined to get her girls back, Christy divorced Paul, worked 2 jobs, and attended mandatory classes and therapy sessions, riding for hours in DHS vans to get to them. Then, the night before Logan's first day of kindergarten, something happened. There was a physical incident between Mary Beth and Logan, an incident both Mary Beth and DHS refused to discuss. Whatever took place in Mary Beth's home, DHS moved quickly to find a new foster placement for the girls. They turned to one of their own, Sally Schofield. Department rules normally bar caseworkers from becoming foster parents to children within the system. Nevertheless, just a week after the incident in Mary Beth's home, Sally received a call from caseworker Allison Peters.
Allison told us that, the girls were beautiful little girls. They didn't have any issues. They didn't have any behaviors. They had to move the girls, and they were heading for TPR.
Termination.
Right.
Terminating Christie's parental rights would free the girls to be adopted.
The plan was that they would be freed for adoption. So at the time that the girls needed to move, the department wanted to find a family that would take them now and then ultimately down the road adopt them so they wouldn't have to move again. And that was you. Right.
Did you get the sense when Logan was brought to you that she was a difficult little girl? Did anybody tell you she was a difficult little girl?
No, actually, what we were told was that they didn't have any behavioral problems. And there were no known emotional problems.
Logan.
The girls moved in with Sally in early September 2000. She took to them immediately.
We fell in love with those girls probably that first weekend. These were our children. And we didn't treat them any differently than we did the boys. I mean, they were our children.
Yeah.
Bailey's big trick.
While Sally sought to win the girls' trust, DHS cut back Christie's visits with them. She would have to provide her own transportation, though she didn't have a car. She was not allowed to know Sally's address, last name, or occupation. By the time she arrived at Sally's, Logan was in her 3rd foster home in 4 years of life. Sally would be the 4th woman to assume the role of mother.
October 12th. Logan kept telling Mom throughout the visit that she was her favorite person in the whole world.
Come on, open it. I want to see what you got.
As the visit was ending, Logan ran to Mom and said, "I want to go home with you." Christy said, "That's not possible, and you have a lot of things to keep you busy, like swimming and dancing lessons."
You're rich. Show me. Wow. What are you going to do with all that money?
I'm going to pretend somebody's going to buy.
October 30th. Logan tells Christy, "I don't like Sally." Christy replied that Sally seemed like a very nice lady, did many nice things for the girls, and dressed them beautifully. Logan burst into tears, and Christy held her and told her that she would always be there for her. December 7th. Out of the blue, Logan said, "Do you know what Sally looks like?" Christy said, "Yes, I have seen her." Logan said, "I don't like her."
While a DHS visit supervisor sat listening, Logan told her mother that Sally had hurt her.
Mommy? Well, just so you know, Daddy, my both of them?
No, I never done the boss enough.
cried in the whole street.
What did you do to him? I'm very sorry.
And she did it to my sister too.
It still has stunned me what would make a 5-year-old stop opening Christmas presents. On that day, I did say what she did to me about Sally grabbing her face, making her hurt, and her sister too.
In early January 2001, during another supervised visit, Logan again told her mother that Sally had handled her roughly, wrapping her up in a blanket. And again, Christy was signaled not to pursue the matter. DHS's own rules require caseworkers to visit every foster home quarterly and to promptly investigate any complaint of physical abuse. Allison Peters did neither. By January, Sally had quit her job as a caseworker, and DHS had decided to pave the way for her adoption of the girls, despite clear and repeated warnings that she was having a difficult time dealing with Logan. On January 8th, just 5 days after Logan's last allegation, Allison Peters emailed Sally. Christy is still up to her old tricks, so she continues to make termination of parental rights easier and easier to get. In late January, Christy wrote what would be her last letter to her daughters.
Dear Logan and Bailey, my sweet little ladies, I think of you so much and often it seems hard to believe you girls have been gone so long now. In a month or so, I stand the chance to lose the both of you forever. It's been no picnic, but this is not your fault. It's mine and mine alone. From what I understand, you girls have things I couldn't or didn't know how to give to you. But I'm trying to learn, and I hope someday you will forgive me for messing up your lives. Please don't forget me. When the day comes you need me or want me, you'll find me. I love you girls forever and always. Love always, Mom.
Sally put Logan in an unfinished portion of her basement in a high chair.
So I went upstairs and put pork chops and baked potatoes in the oven, and I had been up there 3 minutes, and I came back and she was quiet, and I said, "Are you done?" And she didn't answer.
Sally would later say she found Logan lying in a heap on the floor, still confined to her high chair. She wasn't breathing.
I tried to work out. I was okay. She's not breathing at all? No, I can't do it.
Logan was rushed to Maine General Medical Center, where she was pronounced dead. That night, the police came to interview Sally Schofield.
So I went down to the bottom of the stairs and I said, "Logan," and she was on the floor, still in the high chair. And at first I was like, "Oh my God," she hit her head, but she knocked herself out. So I picked her up and I took her out to the bottom of the stairs, laid her down, and at that point I was just, my heart was racing so hard that I couldn't tell if it was her pulse or my fingers. So at that point I was sure that what had happened was she had somehow managed to get herself tipped back and hit her head, and kind of knock herself out or whatever.
Police want to know how 5-year-old Logan Marr died. Emergency crews were called. Logan was in the custody of her foster parents, Dean and Sally Schofield, where she was pronounced dead upon arrival.
Detectives say there were inconsistencies in Sally Schofield's story.
In a subsequent search of Sally's home, police found evidence that raised doubts about her story. Strewn amid boxes in the dank basement were clumps of duct tape, some 40 feet in all. Police tests revealed that the tape had been looped repeatedly around Logan's body and head, and across her mouth. Tufts of Logan's hair could be seen stuck to the tape. An autopsy revealed that Logan had not died from a blow to the head, but from asphyxiation.
They arrested Schofield this morning and brought her here.
What's most shocking about this case is that Sally Schofield had worked for the DHS in the Division of Child Services for years.
Considered a perfect candidate.
She had taped Logan to her high chair and taped her mouth shut. Shortly after, DHS came to the home of their former caseworker.
The department took my children the next day.
Christy did not see Logan until the day of her funeral.
She was partially dressed because I wanted to dress her for the last time. I figured I was the first one to dress her in this world. I wanted to make sure I was the last. I remember I always had a knack for buying the wrong size shoes. I bought the wrong size shoes even for her funeral. They had to cut them. I always tried to gently put them on her feet. And he said, "You're not going to hurt her."
In June 2002, Sally was tried for the death of Logan.
The pre-sentence report has concluded.
Sally waived her right to a jury trial. A judge concluded that she had not intentionally killed Logan and dismissed the murder charge. But he found her guilty of manslaughter and sentenced her to 20 years in prison. No formal disciplinary action was taken against any DHS employees in connection with Logan's death. Allison Peters testified at the trial, but was never asked about her failure to respond to Logan's complaints about Sally. She was placed on paid administrative leave for a month and has since left DHS. Almost a year and a half after her daughter's death, Christy says she was told that Maine DHS had officially closed her case file. Many have worried that the sequence of events leading up to Logan's death was all too common. Dozens of people emerged to complain of mistreatment at the hands of the department.
We're taking kids from places that aren't that bad, putting them in places that aren't that good, and completely leaving out of the equation the bond between the parents and children.
They spoke of a department too hasty in removing children.
They forced me to take him to the hospital for a shaken baby exam, and all of the tests came out negative, and yet they still kept my child based upon I didn't hurt him this time, but I might in the future.
Of a secretive process with little review or oversight.
People who aren't accountable to anybody probably are going to make some mistakes.
The death of Logan Marr focused outrage on a normally secretive child protective system.
Who holds these people accountable? The answer is nobody.
Why was Logan removed from a mother who had never abused her and given to a foster mother who killed her?
The agency did not follow up on a complaint Logan made that Schofield had hurt her.
Who should have kept her safe?
The Department of Human Services did not kill this child.
For many in Maine, it was an abuse of power.
No way should any court in this country of ours ever take a child from its parents based on possible, probable, or maybe.
When a child dies, the child protective system is thrown into turmoil, and it is caseworkers who must bear the brunt.
So upset. Because he's upset, they call him to a bed. Let's be serious, people. He's just, his emotions, his feelings have been played with to the point where he doesn't know, he don't know what's happening.
It begins with a phone call. A teacher, a neighbor, a relative reporting abuse or neglect. In Maine, many caseworkers have less than 2 years' experience. 2 decades ago, the child welfare system was focused on preserving families first. Before losing custody of their children, parents were often given years to turn their lives around. But today, the pendulum has swung. caseworkers place the safety of children above all other considerations, including parents' rights. Under this pressure, caseworkers are now intervening in families earlier and more aggressively, taking on cases they might once have passed over. Twice as many cases now involve neglect rather than abuse, a definition that is often much more ambiguous.
Let me ask you, what is neglect? What do you think?
What about the child that just nobody pays attention to? They don't listen to the child. They don't hear him. The child doesn't exist other than the fact that there's a picture on the mantle.
New at 5:30, a former DHHS caseworker convicted in the death of a 5-year-old girl will soon be released from prison. Sally Ann Schofield was convicted in 2002 and is serving a 20-year sentence for killing Logan Marr. But as CBS 13's Jennifer Long found out, she's expected to be out next month. And Jen, this does come as Logan's mom is fighting a battle of her own.
Well, John, I spoke to Christy Darling today. She told me in January she received this letter notifying her the woman who killed her 5-year-old daughter will be released from prison in April. And in the same month, she was also diagnosed with stage 4 lung cancer. While she's fighting for her life, she's also fighting to keep her daughter's memory alive and remind others not to take anything for granted. Darling says the sentence Sally Ann Schofield served is not nearly enough. Schofield was convicted of manslaughter in the death of Darling's 5-year-old daughter, Logan Marr, in 2002. Schofield was a DHHS caseworker. Logan and her sister Bailey were foster children in her care. Logan suffocated after Schofield duct taped her to a high chair in her basement. According to the Department of Corrections, her release date is April 25th of this year. Darling says that's too soon.
I don't think it's right. I can call and write letters to a correction officer and express my wishes, but it doesn't change the daily struggle with that, the heartache that comes with it. But I can't bring her back, but I can show that there's going to be justice out there, that we can't allow that to happen. It's not okay. It's just not.
Darling had her second lung biopsy yesterday, and her doctors are trying to figure out the best treatment for her right now. She says she's in a wheelchair most days and hoping to relocate to a space that's more practical for her needs. We do have a link to a GoFundMe page for Darling on our website, WGME.com.
So in other news today, a Kennebec County judge has ruled that the press and the public have no right to information about Marissa Kennedy or Kendall Chick. The two young girls were murdered less than 3 months apart, allegedly by their caretakers. New Center, Maine filed a lawsuit after the DHHS commissioner refused to tell the public what he knew and what his department did to protect these girls.
A judge ruled that the commissioner, with the Attorney General's advice, had the full power to withhold information and that neither New Center, Maine nor the people of Maine can challenge his decision. Christina, we brought this to court because so many of our viewers were demanding answers.
Yeah, Lee and Lindsay, they were. And today I actually talked to a former DHHS commissioner who still says transparency is key. Michael Petit went through a similar situation when he was commissioner in 1984. A child was murdered by her stepfather, and Petit says his transparency led to a major DHHS overhaul.
We tried to be as transparent as possible.
It was 1984. 3-year-old Garyana Quinn was beaten to death by her stepfather. Michael Petit was the DHHS commissioner. He says his office immediately drafted a report of its involvement with Garyana, how it intervened, and when.
And from that, they crafted 100 or more recommendations on how to do the work differently, better.
The information was released before the accused killer's trial, and Petit says it led to a major shakeup of DHHS protocol. In cases where a child dies, urgency, he says, is key.
There may be things that are going on right now that could be stopped that need public support, and there's no action being taken on it. There's no sense of urgency because people don't know the facts.
That's why Petit believes the current commissioner, Ricker Hamilton, is making the wrong choice by withholding information about Marissa Kennedy and Kendall Chick.
In my mind, he's to stand up and say, this is what happened, this is our role in it, there's some information I can't provide with you based on the criminal proceedings, but here's what I can tell you.
Petit says at the very least, the commissioner should give the public hypothetical scenarios and basic information about policies and procedures.
All of that is general, and yet it would inform this case because the public has no idea how they actually conduct their business.
The judge sided with DHHS and ruled that the Kendall Chick and Marissa Kennedy cases are confidential and will remain so until 3 criminal trials are complete. Therefore, neither New Center Maine nor the average Mainer can access this information. Petit understands the judge's ruling, but doesn't agree with the commissioner's decision to stay silent.
Openness is what fosters learning and growth and change on this. And to the extent that they're huddled in their offices, afraid to interact with the public will respond harshly to them, and that only hurts children.
So the logical next question is, what next? Well, we could appeal the judge's decision, but we've decided not to do that because our lawyer doesn't believe we have a chance of winning an appeal in this case. But to be clear, the commissioner, the DHHS commissioner, still has the right and the power to change his mind and release this information to the public should he choose to. Okay?
Now Lieutenant Andrew Demarest tries to rescue a jealous man from his own demise.
The most frightening thing for a cop is when he finds himself in a situation where the rules don't work and the clock is ticking. Sometimes the people who are causing harm can be talked to, but there's also those that aren't playing by any rules, and certainly not yours.
Colonel of the Maine State Police will undergo a mental exam to determine if he is competent to stand trial on charges he sexually assaulted a 4-year-old child. A lawyer for Andrew Demers says a judge approved his request that he be examined. The exam has not been scheduled yet. Demers was indicted last spring on charges of gross sexual assault and unlawful sexual contact. Demers served 26 years with the Maine State Police, retiring in 1993.
Ex-Maine State Police Chief pleads guilty to sex assault, and he'll serve 4 years. Andrew Demers Jr. is sentenced to 5 years in prison with the final year suspended on a charge of unlawful sexual contact. And he's a 26-year veteran, twice named Trooper of the Year. He pleaded guilty to sexual contact. One of the most highly decorated police officers in Maine's history was sentenced Tuesday to 4 years in prison for sexually assaulting a 4-year-old child. Andrew Demers Jr., the former chief of the Maine State Police, broke down sobbing at one point during the sentencing at the Cumberland County Courthouse, wiping tears from his eyes many times after he entered a plea of guilty to a felony charge of unlawful sexual contact. Superior Court Justice Thomas Warren sentenced Demers to 5 years with the final year to be suspended, while Demers serves 3 years probation term. The judge also ordered Demers to pay $5,000 restitution to pay for past and future counseling for the child. Demers' arrest on March 17th shocked the state's law enforcement community, many of whom had considered him a model officer. Demers is the only officer in Maine history to be twice named the State Police Trooper of the Year and was named Legendary Trooper in 2003. He served 26 years with the state police and held the department's top position from 1987 to 1993 when he retired. As Warren issued his sentence, he rejected a claim by Demers' clinical psychologist that Demers' actions were out of character and may have been the result of neurological damage from post-traumatic stress from decades of police service. Crimes like this come from a dark place within a person that are often buried deep within and unknown, Warren said at the end of the 3-hour hearing. The courtroom was filled with Demers' family members and supporters, many of whom spoke on his behalf or submitted letters attesting to his exemplary character. At the side of the courtroom, the child's parents sat silently near Cumberland County District Attorney Stephanie Anderson, who prosecuted the case and asked for a sentence of 8 years. Before he was arrested, Demers admitted to investigators to assaulting the child multiple times. State police first received a tip about the alleged crimes on March 10th and referred the matter to the district attorney, who asked the sheriff's office to investigate. Anderson said in her 34 years practicing criminal law, she has made thousands of sentencing recommendations, but found Demers' case to be one of the hardest. This is not something I take lightly at all, because Colonel Demers was my hero too, Anderson said, but later she added, there's no evidence of diminished mental capacity. That's why I say we have a child molester here. Anderson read emotional letters from the parents of the victim, although they did not stand to address the court themselves. "He took my little girl's innocence from us," the child's mother wrote in the statement. Demers' attorney, Walker McGee, argued that his 74-year-old client has already been punished seriously since his arrest, with a ruined reputation and a heartache, and the heartache his actions have brought on his family. And he is, by every single account, the last person that anyone ever expected would be involved in an offense like this. And this alone speaks volumes about who Andy is, as he has lived his life in a way that his farthest cry from behavior at issue here than one can imagine. McGee wrote, there are also very real significant concerns about Andy's safety while incarcerated in custody of the Department of Corrections. Indeed, they don't like child molesters in jail even. The judge rejected McGee's request that Demers be allowed to serve a lesser sentence in the Cumberland County Jail instead of prison, but allowed him a 1-week delay before beginning his sentence on November 11th. Demers broke down sobbing as his adult granddaughter spoke at the hearing about how his actions have affected their family. He spoke through tears as he stood to address the court, pulling a handkerchief from his suit coat to wipe his eyes. Your Honor, since my arrest I have been torn with shame, Demers said. He did not answer reporters' questions when he walked out of the courtroom afterwards with family members. Demers pleaded guilty as part of an agreement reached by McGee and Anderson, in which more serious Class A felony charge of gross sexual assault was dismissed. He could have faced up to 30 years on that charge, so he got off extremely light, I would say. District Attorney's Office and McGee arranged for Demers to turn himself in at the county jail.
This is a good team. This is Governor Paul Richard LePage. I would like to talk to you about your comments about my being a racist, you cocksucker. And I want to talk to you. I want you to prove that I'm a racist. I've spent my life helping black people, and you little son of a bitch, socialist cocksucker, I need you to, I want you to record this and make it public, because I'm after you. Thank you.
I was really glad that I wasn't in the room with him when he left it, because he really sounded like somebody who, was about to commit physical violence, and it was really a stunning message.
This afternoon, LePage apologized for the people of Maine having to hear the voicemail, but not for the voicemail itself.
Everything I said to him is less insulting to me than being called a racist.
After leaving the voicemail, LePage then said he wanted to challenge Gatine to a duel and point his gun, quote, right between his eyes.
The governor later challenges Gatine to a duel.
That's how angry I am. And I bet, and I wouldn't put my gun in the air, guarantee you. I would not be Hamilton. I'd point it right between his eyes.
LePage is no stranger to controversy.
I was Donald Trump before Donald Trump became popular.
Something he himself acknowledged in his endorsement of Donald Trump earlier this year. But the parallels go further. An outsider riling up the establishment, a fighter willing to go to the mat with political foes. LePage's daughter even works for Trump's campaign. And yes, he's a politician with a history of not so politically correct comments. From strong words to President Obama.
And as your governor, you're going to be seeing a lot of me on the front page saying, Governor LePage tells Obama to go to hell.
To punctuating a dispute with the NAACP like this.
Tell him to kiss my butt.
And recently, on the father of a Muslim American soldier killed in action in Iraq.
Then there's the mighty powerful ones like Mr. Khan, which is a con artist himself, and he uses the death of his son, who's an American soldier, which we respect and honor, and he uses that to go after Trump, which I found very distasteful.
But it's comments related to the state's heroin crisis that have followed LePage for months.
These are guys that are named D-Money, Smoothie, Shifty, these type of guys that come from Connecticut, New York. They come up here, they sell their heroin, then they go back home. Incidentally, half the time they impregnate a young white girl before they leave, which is a real sad thing, because then we have another issue that we got to deal with down the road.
The governor of your state called you a lot of things I cannot repeat on the air multiple times. What's your response?
Well, it was pretty shocking to get that voicemail yesterday. I've never received a voicemail like that before, and you know, this is a governor, as you pointed out, who continues to cross the line. And every time you think he's crossed a line, you think he can't go any further, but then he draws a different line and he crosses it. And this is a pattern of behavior by this governor, and it's really unfortunate, because I think Maine people really deserve a lot better from their governor and from the leader of our state.
Has he spoken to you since then? Has he pulled any of this back, at least apologized for some of the vitriol in that call?
No, he hasn't pulled anything back, in any comments that he has made to me. That's not his style. This is a governor that likes to double down, and it doesn't surprise me that he hasn't pulled back the statements, and I don't really expect him to.
Now, he says he made the call because he says that you called him a racist, or a reporter told him that you called him a racist. Did you accuse him of being a racist?
No, I'm not a name caller. I'm not going to play that game with the governor. I was asked to respond to the comments he made about our drug crisis, and I said that racially charged comments are not going to help us solve this extremely serious problem that we have up here in Maine.
You little son of a bitch, socialist cocksucker, I want you to prove that I'm a racist. This freaking...
Give it to the people without providing Vaseline.
This freaking...
Impregnate a young white girl.
I want to talk to you, cocksucker. This freaking... You little son of a bitch, socialist cocksucker, prove that I'm a racist.
Now, the traffickers, these are people that take drugs. These are guys that are named D-Money, Smoothie, Shifty, these type of guys that come from Connecticut, New York. They come up here, they sell their heroin, then they go back home. Incidentally, half the time they impregnate a young white girl before they leave.
I want you to prove that I'm a racist.
Why am I going to go up and face people and talk to them in an audience that just the day, a week or two before they're trying to impeach me? That's just silliness. So why don't we I'll go to work, keep working, I'll send them a letter, and we call it a day.
Governor Paul LePage doesn't want to give the state of the state this year, not if it means talking in person to the legislature that just debated impeaching him. He raised the prospect that he might skip the whole speech this year, submit it in writing instead. But then the impeachment thing fell apart, and now we're left with this interesting open question. Since it turns out you're not being impeached, Governor, is the speech back on? Or are you still literally going to mail it in for Maine's State of the State this year? Simple question. We reached out to the governor's office to ask. And I got to tell you, we do this kind of thing all day long, getting basic information from all different kinds of public officials. This is what we do. This is a normal thing. This is what we sent. Hi. Wanted to see if the governor's made a decision about whether or not he'll give the State of the State address in person to lawmakers, or if he still plans to send a letter. Do you have any information on that decision yet? Thanks. Simple question to the governor's office, right? This was the response we got from Paul LePage's office. Look at this. This is the whole thing. Quote, "Why does Rachel Maddow have such an unnatural obsession with Governor LePage? Her neurotic fixation on him is kind of bizarre." That was the response from the governor's office. That was the whole thing. It's very strange. So we tried again. Is this seriously your response? Should we take this to mean that the governor has not yet made up his mind? Response from Paul LePage's office. Quote, It's a serious question. Does Rachel have ties to Maine? If not, what's her weird fascination with him? So that's a no? We try it again. Hi. Wanted to try one more time on our question about Governor LePage's State of the State this year. Has he made a decision about whether he will give the State of the State address in person or if he will just send a letter instead? We really are just looking for an answer to that question. If you can't answer it, is there someone else we could try to speak with? Thanks very much. Governor's response. Quote, of course I can answer it, but you first. What's with Maddo's obsession with the governor? Admit it. At this point, you'd start to be a little obsessed as well. So we went back once more to the governor's office. This is becoming a strange interaction. We're just trying to get some basic information about a statement the governor made. We are covering this like we would any other newsmaker or public official in the country. Our obsessiveness is only about the news. And Governor LePage is making it hard to get basic information about the governance of that state, and that is starting to feel newsworthy too. Response from the governor's office. Bupkis, nothing. So seriously, I cannot tell you whether or not Maine is getting a State of the State address this year because the governor apparently finds it very offensive that I would even want to know. So all I can tell you is that the State of the State address usually takes place by early February. But apparently you're a sicko if you want to know any more about it than that. So says the governor of that fine state. Just amazing.
Give it to the people without providing Vaseline. Going impromptu in my brain didn't catch up to my mouth.
The governor of Maine, Paul LePage, has now taken over the record of being the dumbest governor in America. And I say that because he went on a radio show to discuss the election, and look at what he said about Donald Trump.
Sometimes I wonder that our Constitution is not only broken, but it needs to, we need a Donald Trump to show some authoritarian power in our country and bring back the rule of law, because we've had 8 years of a president that just is an autocrat. He just does it on his own. He ignores Congress, and we're slipping every single day. We're slipping into anarchy, and I just think that 4 more years of a similar mentality is going to destroy this nation.
That is literally the dumbest thing I've ever heard in my life.
I've thought a lot about this, and I think that Maine, what we need in Maine is we need younger people. Take a look. It looks almost like a lecture for Social Security in here. Okay, so that's one thing. We really need to encourage as many young people. We also need more women. Today I saw a thing that said a lot of men, white men, were committing suicide. And I almost thought, yeah, great. And then I thought about it a little more, and I thought, well, maybe you shouldn't say that in public.
It really shows the amount of bigotry and racism in the Democrat Party. His name is Richard Falkman, okay? So Mr. Richard Fuckman, okay? No, it's Falkman. Basically, he's joking and gleefully laughing and praising the apparent high suicide rate in white males. Now, here's the thing. I personally think suicide is a cheap cop-out. Unless you're like in chronic pain or whatever, just basically getting out of life the short way just because it gets tough, for me is a cheap cop-out. You know what I'm saying? But that goes beyond the point. So this guy is a state senatorial candidate. And the people in this video are not just ordinary Democrats. These are not people who, this guy, for example, these are not just, this isn't like a gathering of, Democrat citizens, random people, okay? This is the Democrat Party. Yes, the private party. This is actually representative of the Democrat Party itself, okay? You'll notice the whole crowd laughs and cheers because apparently white men, there has been an increased likelihood of white men committing suicide in the United States. Now, here's the thing. I cannot say that I think that suicide, I'm not going to empathize with those guys. I don't give a shit. I'm not like that, okay? Because I think suicide's a cheap cop-out. However, for somebody in a position like this guy, This isn't just like your average Joe thinking it's funny and praising the fact that white men have been tending to commit suicide at a higher rate in the recent decades. This is people who lead. This is leaders in the Democrat Party, or people who are vying for leadership in the Democrat Party. So this is fucking disgusting to see people like that, okay? People who think the suicide rate among any group of people is fucking hilarious. You know, I wonder what would happen if, say, a Republican joked about the high murder rate among blacks. Oh, this is going to be great for us since most blacks are Democrats, or black men are Democrats. Thank God they're killing each other. Ha ha ha. Right? It's one thing for your average Joe to joke about shit like that. Or maybe, someone who has not been in politics their whole life. But for actual leaders or people vying for leadership in these political parties, for people to think it's funny that there are people that are killing themselves as leaders in the community, and to be encouraging that, it's ridiculous. Basically banking on the fact that the demographic that you don't like is killing themselves. Well, good luck in Maine. Good luck in Maine. Because there's a lot of white men in Maine. Hopefully this costs you guys some votes.
You know, today I saw a thing in that said a lot of men, white men, were committing suicide. And I almost thought, yeah, great. And then I thought about it a little more, and I thought, well, maybe you shouldn't say that in public.
But know this, if you're a white male, or worse, a straight white male, their behavior makes a lot more sense when you realize they literally hate you and want you to die as soon as possible. On that sad note.
Basic. Much of the state has been losing people, and that is going to get worse. What it means is that there will be fewer young people for schools and fewer adults to take the jobs to keep the state working.
Government and businesses are worried, and they're looking for ways to fill the gaps that already exist. The hope is the young people will come home and others will move here. News Center's Don Carrigan has been looking into the numbers and what they mean. Don?
Hi, Pat and Cindy. This is a complicated issue. We've talked a lot over the past few years about Maine's aging population. Well over 21% of us are now over age 65, and that now includes me. But what we haven't talked about as much is why Maine tops that list. Other states, plenty of them, have a lot of older people too. But Maine's problem is that we have a declining number of young people. Flowers help to frame our lives. Flowers for Valentine's Day, of course, and sometimes flowers to celebrate our babies and to mark our funerals. Here in Lincoln County, where I live, a lot more of those flowers go to funerals. Last year, 424 people died in Lincoln County, but only 272 were born. And this county is not alone. Statewide last year, about 13,600 people died, but only 12,500 were born. The state says it was the fourth year in a row that more people died in Maine than were born. And while we often talk about Maine's aging population, many of the experts say the real worry is that there are fewer and fewer young people growing up here to take our place.
But it's becoming a real obvious and an urgent issue to tackle.
Jonathan Labonte heads the governor's Office of Policy and Management.
It's a real challenge, and I'm not sure folks fully have a handle on how dire the situation is.
At businesses like Volk Packaging in Biddeford, they're already seeing it.
This is all inventory area.
This third-generation family business has about 83 employees designing and making cardboard boxes. HR Director Atoka Dumont says finding new workers is not easy.
At Volk Packaging right now, our average age is about 45. And so we're needing younger people to come in and learn the trades and learn and to grow and progress in the companies.
Projections by the state economist show that only 4 Maine counties will grow in population between now and 2034. The rest will continue to decline. Maine hospitals say they're already trying to plan for it.
Yes, we need to train nurses. There's a nursing shortfall projected over the next 10 years of anywhere between 4,000 and 9,000 nurses statewide.
Maine General HR Director Rebecca Lamy says she thinks they can find the next generation of nurses, but will need help.
We have plenty of students who are interested in healthcare careers and nursing careers in particular. They apply to schools. The schools can't currently handle the number of nursing applicants that they have.
She says nursing schools will need more faculty and resources to meet the need. Just about everyone we talked with said the real challenge is simply getting more people to live and work in Maine, convince high school and college graduates to stay and others to come home, and then convince thousands more across the country and around the world to want to move here.
We're here to go.
Jamie Pacheco and her fiancé, Nate Wiles, are helping to lead the way. Both Maine natives who met at the University of Maine moved away and have now moved back home.
Most of my friends, we all took off to different corners of both the world and the United States, and almost all of us have come back.
Jamie is now running the New Beat Market in Brunswick. And Nate,
we came back because we saw, we felt, and we seized opportunity.
Is now working for Live and Work in Maine, an online resource and outreach effort to show tourists, Maine college alumni, and others they can move here and find good jobs. Live and Work in Maine was started by Portland job recruiter Ed McCursey.
I'm bullish on Maine. I actually believe that there are a lot of quality of life advantages that total out to be a competitive advantage for us.
Nate and Jamie say Mainers need to encourage their kids and relatives to look for opportunities here, and we need to do more.
The numbers in Maine certainly don't work without immigration. Immigration from overseas, immigration from within the United States, from other states. It's really important that Maine is welcoming to folks who want to be here, no matter where they're coming from.
Jonathan Labonte says so far, not enough of those people are coming.
We talk about, in-migration or international in-migration, but, even that's not keeping pace with the loss of workers.
They all say business and government have to develop new game plans to make Maine a more attractive place to work and live. None of them think it will be easy, but they say Maine's future depends on turning the numbers around. Now, besides the need to train more Maine nurses, the dean of the College of Engineering at the University of Maine says the state needs a big investment to train more engineers. He says that they expect 2,500 engineers in the state to retire over the next 10 years, and that currently Maine does not have the capacity to fill that gap. We'll be reporting more on this in the months ahead and looking for ideas that could help. To do that, we'd also like to hear your ideas. Please go to our Facebook pages where you can answer the question that we ask: what can Maine do to help keep and attract more young people to live and work here? Big problem, Pat and Cindy.
It is.
We don't have the ability to significantly grow our population ourselves.
It says the number of employees older than 45 will drop by tens of thousands in the next 8 years. A workforce slowly being whittled away.
Our demographics present a real challenge.
A lack of workers could cause huge problems for local businesses.
You've got to have it. If you don't, you're not going to make it here.
And in a state that is more than 93% white,
we will need to attract thousands of additional immigrants to this state to have the workforce that will enable our industries to thrive.
We are in 2013 right in the transition phase between the old economy, where labor was relatively easy to find, and the new economy, where it's going to become increasingly scarce.
He says the numbers are clear: an aging population, a low birth rate over the past few decades, more young people leaving the state, and few moving in. And Colgan says that's just the start. 5 years from now, will we be needing more?
Yeah, we'll be needing more, actually, probably through the 2030s.
His numbers are getting attention. The alarm was sounded just last week by the Maine State Chamber of Commerce and the Maine Development Foundation.
Now, who would want to live in a place like this?